Here's a story about judicial authority, legal ethics, and a moment that shook the legal community to its core. A federal judge made a decision in open court that legal experts are still debating today. What happened in that courtroom raises important questions about the balance between catching misconduct and protecting constitutional rights. This case has become one of the most discussed legal events in recent federal court history, and for good reason. The case itself was already generating significant attention. A high-profile fraud trial involving millions of dollars, powerful individuals, and complex financial instruments had been proceeding through the federal court system for months. The kind of case that attracts media attention, public scrutiny, and the best legal minds money can buy. Judge Caldwell, a federal judge with over 2 decades of experience on the bench, had been presiding over this trial for 3 months. 3 months of complex motions, heated objections, and increasingly sophisticated legal maneuvering from both sides. The prosecution presented evidence of systematic financial fraud. The defense countered with explanations of legitimate business practices misunderstood by investigators. But something felt wrong to those watching closely. The defense team seemed unusually prepared, almost prescient in their ability to anticipate prosecution strategies. Their cross-examinations were remarkably effective. Their witness preparation appeared to go beyond normal legal practice. Court observers noticed, journalists commented, but proving something was amiss proved impossible. On what seemed like an ordinary Tuesday morning at 10:47 a.m., Judge Caldwell called a standard 15-minute recess. The jury filed out of courtroom 4B. The prosecution team gathered their materials. Court staff took their break, and the defense team huddled together at their table, speaking in low tones, believing they had privacy. The courtroom's audio system, installed years earlier for ADA compliance and official record-keeping purposes, includes multiple microphones strategically placed throughout the room. During active proceedings, specific zones activate to capture testimony and official statements. During recesses, the system typically goes dormant, providing privacy for sidebar conversations and attorney strategy sessions. Typically, but not that day. A technical malfunction, or perhaps something else depending on who you ask, kept the defense table microphone active. The system continued recording when it should have been silent. And what it captured would lead to one of the most dramatic courtroom scenes in modern federal court history. The conversation lasted several minutes. The lead defense attorney spoke in hushed but audible tones. References were made to witness testimony, to statements that had changed, to information that one party possessed and another didn't. The exact contents of the recording have been debated and analyzed, but what's clear is that what was captured raised serious concerns about potential. The courtroom audio system connects to monitoring equipment in the clerk's office, part of standard courthouse security and administrative protocols. When the recording captured the conversation, courthouse staff immediately recognized the potential significance of what they were hearing. Within 60 seconds, the recording was brought to Judge Caldwell's attention. He listened once, carefully. Then he made a decision that would define his career and potentially reshape courtroom procedures nationwide. Judge Caldwell returned to the courtroom. Witnesses who were present that day describe his demeanor as remarkably calm, no visible anger, no dramatic gestures. Just an absolute, almost terrifying composure that communicated something serious was about to happen. He didn't address the jury, who were still in the deliberation room. He didn't speak to the prosecution team. Instead, he looked directly at the defense table and addressed the lead attorney by name. His instruction was simple and direct: remain seated. The lead defense attorney, apparently confused, and perhaps already sensing something was wrong, began to stand anyway. He started to object, to ask what was happening, to assert his rights and those of his client. Judge Caldwell repeated his instruction. The tone left no room for interpretation. That's when the U.S. Marshals moved. Not toward the attorneys themselves, but toward the laptop sitting open on the defense table. What happened next unfolded with remarkable speed. The Marshals, moving with practiced efficiency, approached the defense table with evidence bags and proper documentation. The lead defense attorney protested, invoking attorney-client privilege, arguing that the materials on that table were protected by constitutional safeguards that existed for essential reasons. Judge Caldwell's response was measured but firm. He stated that privilege does not extend to evidence of ongoing criminal activity, a legal principle known as the crime-fraud exception. If communications or materials are being used to further a crime, the normal protections of attorney-client privilege can be pierced. The laptop was secured, then phones, then tablets, then external storage devices. The defense team, 3 attorneys, 2 paralegals, stood and watched as their entire case, their files, their communications, their work product was collected and documented. 45 seconds. That's how long the actual seizure took. 45 seconds to dismantle what had been months of legal preparation. But what most people watching didn't realize was that Judge Caldwell's actions weren't spontaneous. During that recess, after hearing the recording, he had already contacted the U.S. Attorney's Office. By the time those devices were being collected in open court, federal investigators were already being briefed on the situation. This wasn't an emotional reaction by a judge who heard something disturbing. This was a carefully considered legal action based on what Judge Caldwell believed was clear evidence of misconduct occurring in his courtroom. Understanding what Judge Caldwell did requires understanding some complex legal principles. The Fourth Amendment protects against unreasonable searches and seizures. Attorney-client privilege protects confidential communications between lawyers and their clients. These aren't minor procedural rules, they're fundamental constitutional protections. But they're not absolute. The crime-fraud exception to attorney-client privilege has been recognized by courts for generations. The principle is straightforward. The privilege exists to facilitate legitimate legal representation, not to shield ongoing criminal activity. If an attorney and client are using their communications to plan or execute a crime, those communications lose their protected status. Similarly, the Fourth Amendment's protections against unreasonable searches can be overcome when there's probable cause to believe evidence of a crime exists and there's a risk that evidence might be destroyed. Judges can authorize emergency seizures under specific circumstances. Judge Caldwell apparently believed both conditions were met. The recording provided probable cause to suspect witness tampering. The devices on the defense table potentially contained evidence of that tampering. And if the defense team realized they'd been caught, that evidence could be deleted in minutes. From a legal standpoint, his actions had a foundation. Whether that foundation was solid enough to support what he did remains a matter of intense. The courtroom erupted after the seizure. The jury had to be kept isolated to avoid contamination. The prosecution team sat in apparent shock. They clearly had no advance warning of what was happening. The defense team's reaction ranged from outrage to what witnesses described as visible fear. Judge Caldwell suspended the trial pending investigation. He ordered the defense attorneys to remain within the jurisdiction. He prohibited contact between defense counsel and the defendant, the witnesses, or even each other until further notice. These weren't suggestions, they were court orders, backed by the full authority of the federal bench. The lead defense attorney's face, according to multiple observers, went pale. The reality of what was happening became clear. Years of legal education, professional development, and career building potentially undone in minutes. The defense attorney attempted to invoke his client's constitutional right to counsel. Judge Caldwell's response addressed that concern directly. The client's rights weren't the immediate issue. The conduct of the attorneys was... Then came the statement that made every attorney in the courthouse pay attention. Judge Caldwell indicated that federal marshals would escort the defense team for processing. He clarified they weren't under arrest yet, but obstruction of justice, witness tampering, and conspiracy charges were being evaluated. The word "yet" hung in the air like a guillotine blade. The legal community's reaction was swift and deeply divided. Within hours of the courtroom incident, professional organizations began issuing statements. Legal scholars took to social media, cable news, and professional journals to debate what had happened. The National Association of Criminal Defense Lawyers expressed grave concerns. Their statement warned that seizing privileged attorney-client materials without following standard warrant procedures could set a dangerous precedent. They suggested Judge Caldwell might have acted on emotion rather than proper legal authority. One prominent civil liberties attorney framed the concern this way. A judge heard something he found disturbing during what should have been a private conversation and immediately seized property. What happened to the Fourth Amendment? What happened to the careful balance between law enforcement authority and individual rights? These aren't frivolous concerns. The protections the defense bar was invoking exist for crucial reasons. Attorney-client privilege encourages full and frank communication between lawyers and clients, which is essential for effective legal representation. The Fourth Amendment protects against government overreach and abuse of power. These principles matter regardless of whether the people they're protecting are sympathetic. But prosecutors and many judges saw it differently. A former federal prosecutor with over 2 decades of experience said he'd never seen a sitting judge take action so decisive and so fast on evidence of potential witness tampering. Usually these investigations take months. Judges are typically cautious to a fault, waiting for prosecutors to build cases before acting. Judge Caldwell moved like a prosecutor, this expert noted. And legally, he may have been completely justified. This explosion didn't come from nowhere. The trial had been showing irregularities for weeks before the microphone incident brought everything to a head. A key witness, a former accountant who had worked for the defendant, was scheduled to provide crucial testimony about financial records. Her original deposition had been devastating for the defense, clear, detailed, and damning. She described specific instances of document falsification, explained how numbers had been manipulated, and authenticated records that appeared to prove fraudulent activity. Then something changed. 3 weeks before trial, this witness's attorney contacted the prosecution with a revised statement. Suddenly, the numbers she'd been certain about were unclear. The documents she'd authenticated were possibly misremembered. Her rock-solid testimony had turned to sand. The prosecution immediately flagged this change as suspicious. They informed Judge Caldwell that something felt wrong. Had the defense crossed a line in their witness preparation? The prosecution couldn't prove it, but they wanted it on the record. Judge Caldwell acknowledged their concerns, but stated there was insufficient evidence to take action. Suspicion isn't proof. The defense was entitled to the presumption that their tactics were legitimate and their witness preparation was within proper bounds. But people noticed. The defense team's cross-examinations were too perfect. Their objections seemed to anticipate prosecution moves before they happened. Their witness preparation appeared almost supernatural in its effectiveness. Every week, the defense seemed to know exactly what was coming next. Judge Caldwell reportedly told his clerk that something wasn't right. He could feel it. But feelings aren't evidence, and judges can't act on intuition alone. Until that microphone stayed active. Until he didn't have to rely on feelings anymore. Until he had actual, recorded, verifiable evidence. What happened in that courtroom has implications that extend far beyond this single case. Legal professionals across the country are now reconsidering their practices and procedures. Defense attorneys are reviewing how they conduct private conversations in courtrooms. If a forgotten microphone can capture supposedly private discussions, what else might be recorded? How much privacy can attorneys and clients actually expect in spaces designed to be public? Federal courthouses are auditing their audio systems. What equipment is active when? Who has access to recordings? What protocols exist to prevent unauthorized monitoring? These questions weren't pressing concerns before this incident. Now they're critical. For ordinary people who might someday need legal representation, this case raises uncomfortable questions. Are private conversations with your attorney actually private? After this case, the answer is less certain than it used to be. In coming months, expect a flood of motions in cases nationwide. Defense teams will challenge courtroom recording procedures. They'll demand disclosure of when and how monitoring occurs. Cases might be delayed while courts establish new protocols. Verdicts might be appealed based on privacy concerns raised by this incident. The ripple effects are already spreading through the legal system. If Judge Caldwell's seizure is ultimately upheld by appellate courts, it creates a roadmap for judges everywhere. Suspect attorneys are engaging in misconduct. Wait for them to slip up on a recorded conversation and seize everything. From one perspective, this represents accountability. Corrupt lawyers should be caught and stopped. The justice system depends on attorneys acting ethically, and when they don't, there should be consequences. From another perspective, this is terrifying. What happens when a judge is wrong? What happens when an innocent conversation is misinterpreted? What happens when a defendant loses their entire legal team based on a misunderstanding or overreaction? And here's what nobody wants to discuss openly. What if the defense team was actually innocent? What if that conversation was taken out of context? What if references to adjusted testimony meant legitimate witness preparation, helping a nervous witness present accurate information clearly? What if the arrangement referred to a legal fee structure or scheduling accommodation? What if Judge Caldwell, convinced of wrongdoing after weeks of suspicion, heard what he wanted to hear rather than what was actually said? Right now, careers are destroyed. A trial is suspended. A defendant sits in legal limbo. And if it turns out the recording doesn't prove what everyone thinks it proves, there's no undo button. The defense attorneys can't unexperience being escorted from a courtroom by federal marshals. The defendant can't recover months of additional incarceration while this gets sorted out. And Judge Caldwell can't unmake a decision that was witnessed by dozens of people and will be studied for decades. The defense team could have handled the aftermath quietly, working through proper legal channels to challenge the seizure and protect their interests. Instead, they chose a different path. The lead attorney held an impromptu press conference on the courthouse steps. His statement was defiant, angry, and accusatory. He called Judge Caldwell's actions judicial tyranny. He claimed constitutional rights had been violated based on an illegally obtained recording. He vowed to fight to the Supreme Court if necessary. Legal analysts almost universally agree this was a strategic disaster. Attacking a federal judge publicly while under investigation for serious misconduct is rarely wise. One commentator described it as pouring gasoline on a fire while standing in the flames. The situation deteriorated from there. Within 24 hours, supporters of the defendant began appearing at the courthouse, signs, chants, accusations of judicial corruption. The protests were mostly peaceful, but the atmosphere was tense. Online, things turned darker. Judge Caldwell's personal information appeared on social media, his home address was posted, family members were identified. Threats began to surface subtle at first, then increasingly explicit. The U.S. Marshal Service assigned a protection detail to Judge Caldwell. His family was moved to an undisclosed location for their safety. All because the defense attorney couldn't control his reaction and his public statements inflamed an already volatile situation. Several aspects of this case remain unexplained and troubling. First, why was that microphone still active? The courthouse audio system had been in place for over a decade. This kind of malfunction had never happened before. Was it truly a technical glitch, or was something else at play? Second, who was the unidentified voice on the recording? Court filings reference multiple speakers in the captured conversation, but one voice hasn't been identified publicly. The investigation isn't providing answers. Why the secrecy? Third, what caused the dramatic change in witness behavior 3 weeks before trial? The timing is suspicious, but correlation isn't causation. What actually happened to cause a witness to completely reverse her testimony? Sources close to the investigation have suggested that forensic analysis of the seized devices is revealing what they call significant irregularities. That's vague language that could mean anything from evidence of witness tampering to something far more extensive. There are rumors, unconfirmed but persistent, that the FBI's Public Corruption Unit has taken the lead on the investigation. That's not standard procedure for a straightforward witness tampering case. That level of federal involvement suggests investigators believe they're looking at something bigger, something that extends beyond one trial and one defense team. The defendant in this case has connections to political figures, major donors, and influential people who generally prefer to avoid federal court scrutiny. Judge Caldwell knew this case was politically sensitive when he agreed to preside over it. What if the defense team's behavior wasn't just about winning this particular case? What if they were protecting interests that extended far beyond their client? As of now, the situation remains unresolved, but developing rapidly. The trial is suspended indefinitely. The defendant remains in custody with bail revoked, pending the investigation into whether the defense team's alleged conduct compromised the entire proceeding. The lead defense attorney and 2 associates have been suspended from practice pending state bar investigation. Their law firm has gone dark, website offline, phones unanswered, office reportedly closed. The seized devices remain in FBI custody. Forensic analysis continues with no public timeline for completion. But what's not in official reports is potentially more interesting than what is. Multiple sources indicate the recording captured more than has been publicly disclosed. The full audio is allegedly over 6 minutes long, but only portions have been referenced in court filings. What's on the rest of that recording? Judge Caldwell has filed a motion to have the entire audio entered under seal, suggesting the contents are sensitive to ongoing national investigations. National investigations, not local, not state, but national. That's language that doesn't appear in court documents by accident. The next hearing is scheduled for 3 weeks out. Judge Caldwell will decide whether to declare a mistrial or attempt to continue with new defense counsel. But everyone involved knows that whatever investigators find on those devices will determine what happens next. This case has already become a flashpoint for debates about judicial authority, attorney ethics, constitutional protections, and the balance between fighting corruption and preserving rights. Law schools will study this case for years. Appellate courts will likely review Judge Caldwell's actions, creating precedents that affect how similar situations are handled in the future. The fundamental questions remain unanswered. Did Judge Caldwell act appropriately given what he knew? Should judges have this much authority to act on suspected misconduct? How should courts balance the need to catch wrongdoing against the imperative to protect constitutional rights? These aren't simple questions, and this case won't provide simple answers. But it demonstrates something important about our legal system. Justice requires constant balancing of competing principles, and even well-intentioned actions can raise legitimate concerns about power and rights. Whatever happens next in this case will be significant. The investigation continues. Federal authorities are examining evidence. Legal scholars watch carefully. And the entire legal community waits to see whether Judge Caldwell's dramatic action will be vindicated or condemned. One thing is certain. This courtroom moment has already changed how judges, attorneys, and the public think about privacy, privilege, and power in the American legal system. The final chapter of this story hasn't been written yet, but its impact is already being felt in courtrooms across the nation.